Rule 85. Accountability and compensation of executors and administrators. Section 1. Executor or administrator chargeable with all estate and income. Except as otherwise expressly provided in the following sections, every executor or administrator is chargeable in his account with the whole of the estate of the deceased which has come into his possession, at the value of the appraisement contained in the inventory, with all the interest, profit, and income of such estate, and with the proceeds of so much of the estate as is sold by him, at the price at which it was sold. Section 2. Not to profit by increase or lose by decrease in value. No executor or administrator shall profit by the increase, or suffer loss by the decrease or destruction, without his fault, of any part of the estate. He must account for the excess when he sells any part of the estate for more than the appraisement, and if any is sold for the less than the appraisement, he is not responsible for the loss, if the sale has justly made. If he settles any claim against the estate for less than its nominal value, he is entitled to charge in his account only the amount he actually paid on the settlement. Section 3. When not accountable for debts due estate. No executor or administrator shall be accountable for debts due the deceased which remain uncollected without his fault. Section 4. Accountable for income from realty used by him. If the executor or administrator uses or occupies any part of the real estate himself, he shall account for it as may be agreed upon between him and the parties interested, or adjusted by the court with their assent, and if the parties do not agree upon the sum to be allowed, the same may be ascertained by the court, whose determination in this respect shall be final. Section 5. Accountable if he neglects or delays to raise or pay money. When an executor or administrator neglects or unreasonably delays to raise money, by collecting the debts or selling the real or personal estate of the deceased, or neglects to pay over the money he has in his hands, and the value of the estate is thereby lessened or unnecessary cost or interest accrues, or the persons interested suffer loss, the same shall be deemed waste and the damage sustained may be charged and allowed against him in his account, and he shall be liable therefore on his bond. Section 6. When allowed money paid as cost. The amount paid by an executor or administrator for costs awarded against him shall be allowed in his administration account, unless it appears that the action or proceeding in which the costs are taxed was prosecuted or resisted without just cause, and not in good faith. This application will let you trade all assets in the market today, which include stocks, crypto, ETFs, indices, forex, commodities among others. You can also copy the trades of the best traders, which is called social trading or copy trading. Earn rewards. Start by using my affiliate link. I may earn commissions from your registration. Shortly.ai is an artificial intelligence website that creates authentic non-fiction articles that can write you articles in just 2 minutes. Use my link to save in cost. See description of this video. Section 7. What expenses and fees allowed executor or administrator not to charge for services as attorney. Compensation provided by will controls unless renounced. An executor or administrator shall be allowed the necessary expenses, the care, management, and settlement of the estate, and for his services, 4 pesos per day for the time actually and necessarily employed, or a commission upon the value of so much of the estate as comes into his possession and is finally disposed of by him in the payment of debts, expenses, legacies, or distributive shares, or by delivery to heirs or devises, of 2% of the first 5,000 pesos of such value, 1 per centum of so much of such value as exceeds 5,000 pesos and does not exceed 30,000 pesos, 0.5% of so much of such value as exceed 100,000 pesos. But in any special case, where the estate is large, and the settlement has been attended with great difficulty, and has required a high degree of capacity on the part of the executor or administrator, a greater sum may be allowed. If objection to the fees allowed be taken, the allowance may be re-examined on appeal. If there are 2 or more executors or administrators, the compensation shall be apportioned among them by the court according to the services actually rendered by them respectively. When the executors or administrator is an attorney, he shall not charge against the estate any professional fees for legal services rendered by him. When the deceased by will makes some other provision for the compensation of his executor, that provision shall be a full satisfaction for his services unless by a written instrument filed in the court he renounces all claim to the compensation provided by the will. Section 8. When executor or administrator to render account. Every executor or administrator shall render an account of his administration within 1 year from the time of receiving letters testamentary or of administration, unless the court otherwise directs because of extensions of time for presenting claims against, or paying the debts of, the estate, or for disposing of the estate, and he shall render such further accounts as the court may require until the estate is wholly settled. Section 9. Examinations on oath with respect to account. The court may examine the executor or administrator upon oath with respect to every matter relating to any account rendered by him, and shall so examine him as to the correctness of his account before the same is allowed, except when no objection is made to the allowance of the account and its correctness is satisfactorily established by competent proof. The heirs, legatees, distributes, and creditors of the estate shall have the same privilege as the executor or administrator of being examined on oath on any matter relating to an administration account. Section 10. Account to be settled on notice. Before the account of an executor or administrator is allowed, notice shall be given to persons interested of the time and place of examining and allowing the same, and such notice may be given personally to such persons interested or by advertisement in a newspaper or newspapers, or both, as the court directs. Section 11. Surety on bond may be party to accounting. Upon the settlement of the account of an executor or administrator, a person liable as surety in respect to such account may, upon application, be admitted as party to such accounting. Shortly.ai is an artificial intelligence website that creates authentic non-fiction articles that can write you articles in just 2 minutes. Use my link to save in cost. See description of this video.